Welcome to our third Evolve Law event around legal tech, which is now Legal Week. And this year, we're partnered with ALM, and we want to thank them for that partnership. We want to start off by thanking Wolters Kluwer for their sponsorship and Legal Shield, plus LawPay, who couldn't be here. We have 10 or 11 Darwin Talks tonight. We've lost one along the way. And we're gonna bring the speakers up. It's gonna be very rapid fire, like Ignite. So those of you who don't know Evolve Law, Jules and I founded it about 18 months ago. It's kind of an accidental business. We now have over 120 members, and we're all about increasing the adoption of technology in the legal industry. We're not just for lawyers who practice, but also for in-house. And we have a couple of very exciting events coming up. We have a tech-savvy in-house counsel series that we're doing on both coasts. And so if you're here in New York, we have one at the end of April, but we have a couple coming up on the West Coast. We're at Tech Show with a partnership this year as part of Tech Show. We're in the Startup Alley, I think they're calling it, and we're doing basically a pitch competition on the kickoff night, which is March 15th. Oh, I guess that's over there. Okay, so now I've got most of your attention. We have an exciting event coming up April 4th. If you're a legal tech company, an investor, or somebody who wants to partner with a legal tech company, we're doing an investment summit on April 4th. And I will turn the mic over to Jules. Maybe come over here so we don't do this interference thing.
All right, well, thank you everyone for coming. There's room in front. If people over there want to come, just stand right in front. It's going to be the best view in the house, I promise. And thank you for the standing room only crowd. We appreciate it. The other thing we'll mention about that we're doing with Evolve Law, there's a lot of little tiny writing up there, but basically we're excited to launch our first tech fellowship, and this is focusing on document automation. It's a crash course in document automation for in-house counsel and legal operations professionals, and we've got 10 awesome innovator software company providers participating and 20 in-house counsel. So there's still room to nominate people, so check out the website and nominate your favorite attorney for that, who you think could use some document automation in their life. And we'll be replicating that with other legal industry verticals in the future. So with that.
Okay, we're going to get started with our Darwin Talks. A is for Alma, so she's going to come up. And what we're going to do is this year we're not going to introduce, and because you're all standing, we're just going to go rapid fire through each of them. At 4 minutes and 30 seconds, you can look, I'm going to kick Karsten out of his seat, even though he's come all the way from Germany, and that's where I'm going to sit. And I'm going to wave at you at 4 minutes and 30 seconds, and then you have to wrap up by 5 minutes. So we have 11 amazing talks tonight, and then we will continue the drinking and eating all the food.
Hi everyone, thanks for coming tonight. So the topic of my talk is outside counsel versus corporate counsel, who's driving legal tech adoption. And recently I've been doing a lot of market research, reading a lot of studies. It may be shocking to all of you to know that in-house counsel don't think very much of outside counsel's efforts to change their service delivery model. So you can see here that they get a median 3 out of 10 rating. And so the question is, why? Who's driving legal tech adoption? And the answer seems to be conflicting. So partners resist change efforts and clients are asking for it. And it was when I read that fact that I was like, well, wait a minute, then how's it ever gonna happen? And as a startup, we often hear from people in the industry and they say, well, go to outside counsel and outside counsel will force the law firm to use it. Seems reasonable enough, but if you look at this, that's not the case. So when you dive a little deeper, clients are out there saying, we want more for less, we want more for less. But what does that mean to law firms? Law firms say, okay, we'll give you the same services, but we'll drop the price. Now, as any of us in here know, that's not a sustainable model. Eventually, the law firms are going to keep dropping the prices, and law firms start going out of business. They start struggling to turn a profit, and they're probably delivering less for less because now they can't deliver the same quality of service that they were before. So the big question is, why then aren't clients going to law firms and saying you need to change your service delivery model? Why aren't they doing what everybody tells the startups that they will do? And the answer is interesting in that they are focused on just the price. They don't want to get involved in how the sausage is made. They don't really care to tell the law firm how to do their job. What they care about is what is the price at the end of the day. Or they're just switching law firms. So if this law firm isn't, delivering more for less, then they'll just go to another firm, or they'll bring it in-house. And that was the major trend that was surprising to me, is how much corporate counsel are bringing tasks in-house that used to be done by outside counsel. And so where does that leave us when we go to law firms and we want to see lawyers change their service delivery model? Well, option A is that if the law firm doesn't change it, then corporate counsel are just going to go to law firm B. So, when we go to law firms, we need to be explaining this to them and telling them, it's not that you should be sitting around waiting for your clients to ask for it. You actually need to be proactive in changing. And the studies show that firms that are proactive in changing their service delivery model are actually becoming more successful, which flies in the face of this sort of partner reliance on the billable hour model. Now, option B, as I mentioned before, corporate counsel are bringing it in-house. They're just doing it themselves. More and more corporate counsel are hiring their own paralegals and saying, you know what, we'll take over the paralegal work and we'll work with the case team at the law firm to build the case. So for those of you waiting around for option C, where outside counsel is going to come in and tell the law firm how to do their job, that's just not happening. The studies out there show that corporate counsel are not going to come in and do that. And so then how do we as startups get law firms to change their service delivery model? Well, either we have to work with the partners and we have to lay out the facts for them and explain what's happening in the market. And this is particularly challenging in that partners' resistance is actually increasing, not decreasing over time. But we have to find ways to get through to them and explain how changing their model can actually make them more money. We have to find out what's important to them and go after that. Again, and I'm going to keep saying it, we cannot rely on the idea that corporate counsel are going to come in and tell them. And if a partner tells you, well, we're going to wait until our client asks us to change, you have to tell them that's not going to happen. They're just going to go with another firm, or they're going to bring the work in-house. And the more I start talking with partners about this, the more they've been going, oh yeah, they have been bringing more work in-house. Or we go to corporate counsel, but the message is not what I thought it would be, which is you go to corporate counsel and try to get them to use their law firm, get their law firms to use your technology. The message is actually how can they use your technology to enable them to take more control over the process and therefore directly control the costs. So that's some of my findings as I've been diving into this area. And like I said, if you're going to drive legal tech adoption within law firms, it's the partners or enabling outside counsel to bring it in themselves. Thank you.
Where's Lori? She's coming. After Lori will be Joshua and Brian. See Brian, I don't see Joshua. Lori doesn't have slides. Yes, because none of you guys look at slides anyway. So we need the mic. But probably a mic. I may not need the mic either. So I wanted to talk about legal hackathons. And how I talk about legal hackathons sort of depends on who's in the room. So I'm going to ask you guys to get involved. Who here is tech? Raise your hand. Okay. Who here is legal? Okay. So it's about half and half. So I'm going to give you both sides. So I'm kind of a nerdy girl, but I'm not a coder, I'm not a software developer. I do love technology, and shockingly, I believe it can improve the legal field. I'm also from legal,
And I believe that not every tech solution is right for the legal field. So that means I sit right in the middle. And one of the things that I got to do this past year was attend my very first legal hackathon. Who thinks people got arrested for the work they did at the legal hackathon? Anyone? Okay, just making sure. So in the tech world, obviously hackathons are normal. These happen. I didn't know these were a thing. And when I heard about it, I thought maybe some people were going to get arrested, and it sounded like a party, so I went. But on the legal side, it seems very, I don't know, rogue. And so we took a group of professors from Vanderbilt Law in Tennessee, a bunch of software developers, and we went to a state bar sanctioned legal hackathon, which meant that we had some great tech, not so many lawyers. I'm hoping today I can convince the legal field to think about a legal hackathon. What we learned during this trip with our techies was, number one, nothing's actually impossible in tech. I think sometimes in the legal field, we think, I hope someday they can build this. What I realized is it's already built. It's already there. Whatever you think your firm needs, someone's designing it, building it, or there's 25 people who already have the product on the market. It was fascinating to hear what kind of problems could be solved. Of course, we developed a model. During this hackathon, we were there to work with legal service providers. So it was all pro bono, it was all civic hacking, feel good, we're gonna change the world. We obviously changed the world, you're welcome. Our team did get to build a really cool app. It happened in about 4 hours, and it was simple. So on the legal side, I'm talking to you now. It took 4 hours for a couple of amazing nerds to build a thing that made communication with their clients really easy. I want you to think about that for a second. It costs $10 a month, and the Red Cross is actually looking at it right now to deploy for their services. 4 hours, 2 nerds. Sorry, nerds. That was amazing to me. That blew my mind. On the tech side, lawyers need this. And what I found really interesting is the thing the lawyers were the most excited about at the Legal Hackathon was one of our tech product managers and product developers actually made a call to an existing product, had them adjust a button, and improve the product for the actual users. The product itself actually created a better product and is selling better. The users are way happier and telling everybody they know. And it was a very simple fix. So what that taught me is we need more cat herders. We need more people in the middle, more people who love technology and understand the legal field. And this room is full of those people. So I'm encouraging you guys, if you have never been to a legal hackathon, find one. If there's not one around you, create one. If you'd like to come to Tennessee, where there's lots of nerds and legal all together who love each other very much, come and see us. We're doing one in April. But just think about taking an alternative way to open the dialogue. What I found the most exciting, cat herders are really effective in both sides because there's a lot of similar personalities. And so it's not as hard to talk to each other when you're in a room creating something for the good of all. And the idea of a legal hackathon, the actual idea of making a difference for nonprofits and doing something good and fun and making some money if you build the right product, can be really, really inspiring. Thanks, guys.
Joshua Lennon.
Okay. Hi, everybody. I'm Joshua Lennon. I'm Clio's lawyer in residence. My Twitter handle is @JoshuaLennon. Tweet liberally. Yep.
It says Columbia Law School. It's
A little bit confusing. I was trying to be clever. That's the PricewaterhouseCoopers logo. right next to the Columbia Law School. I replaced their logo. So the talk tonight is why legal ed should embrace the big four accounting firms. So the National Law Journal every year publishes a ranking of which schools best place law students within big law firms. And for 3 years in a row, Columbia Law School, local school, was able to place close to 50% of their student body, or about 200 law students, within big law firms. The largest amount going to Davis Polk, about 20 students, which has about 900 lawyers and 10 offices around the world. That's not too bad. When you add up the list, law school sent about 3,400 law students to big law, which is a reasonably large number if you don't notice that it's only 10% of the student body. That's ridiculous. We know, and these numbers come from the ABA, courtesy of the Institute for the Advancement of the American Legal System, that 40% of 2015 law grads do not have a job that requires bar passage. 30% don't even require a law degree. 25% couldn't even find permanent employment, period, whether or not it required a law degree. And yet, the percentage of graduating law students who think they have the skills to practice law is at 71%, when rated by law students, 45% when it's rated by professors, and 23% when it's rated by practicing lawyers. These are scary numbers in that we're preparing a massive amount of students to enter the workplace and not either preparing them for the right jobs or actually giving them the availability of the right jobs. And this is an issue that needs to be corrected. And to Columbia's benefit, they are trying to take some efforts in that step. For example, right here, they've come up with a summer internship with eBay where one lucky law student gets to intern with eBay's general counsel and legal departments over a period of about 5 weeks. And that sounds like a pretty cool opportunity, but it's one law student. So we're starting to see other law schools do other things that may help more. This is Miami Lex, and this is a partnership with the University of Miami with United Lex, a company that provides litigation support services. And about 30 law students a year actually go and do 2-year residencies, paid residencies, with United Lex, learning skills like e-discovery, cost controls, risk management. And the University of Miami is not unique in this. Actually, United Lex is paired with about 10 different law schools, pulling 3 to 10 students from each of those. And there are just a couple listed from the website there, but it includes things like Vanderbilt and a whole bunch of other law schools you've heard about. We're starting to create jobs for lawyers, but it's mostly jobs that help law firms instead of helping clients. And that means, I think, law schools are ignoring job opportunities. So what are some of these job opportunities out there? Remember when I talked about how Davis Polk had 900 lawyers out there? Consulting has more lawyers than most big law firms, period. And they're spread around the world. PricewaterhouseCoopers has 2,500 lawyers, and they plan to increase their headcount by about 21%. If you look, they're offering worldwide legal services, with Ernst & Young at the very top doing about 30 different countries offering legal services, and PricewaterhouseCoopers offering them at close to 115 countries. And they're not just practicing the type of law that you think can't be done by lawyers. From PricewaterhouseCoopers, there's tax law, corporate, employment, real estate. We're seeing immigration happen as well. All areas of law are now being open for the big four accounting firms to bring lawyers in-house and start stealing this work away from the legal space. And if you think they're doing it outside of the United States, you would be wrong. Here, 26% of PricewaterhouseCoopers' legal activities are in the Americas. Deloitte's, it's close to 30%. They're already here, but we're not partnering with them. And what's interesting is they plan to keep growing. How many law firms plan to add 21% more headcount of lawyers in the next year? I can't name. Well, we've got one. Well, 0, okay. Yeah, so 0. We don't even have one, but the big four are. And I'm going to tell you about one right now. So this is Egan LLP. It is a Canadian version of this, owned by Ernst & Young. And they have lawyers across Canada in multiple offices. And they're hiring junior and senior immigration lawyers to help out with business immigration from around the world, including immigration to the US, which is something I think we're all getting a crash course on this week. These jobs are out there, but we're starting to ignore them. And if we don't start talking to law schools and law students and inviting these opportunities into our legal space, we're actually going to lose them to the rest of the world. So I challenge anybody here that has educational connections to reach out and tell our law students that they can be accountants too. Thank you very much.
Thank you, Joshua.
Thank you.
Okay, we have Brian coming on up. Jules is tweeting.
Yeah, so I'm Brian Powers. I'm a lawyer, and I'm also a tech company founder. I realized walking over here, I've completed my transformation from law firm lawyer to tech founder because I have a logo shirt under a blazer and these ridiculous shoes that are like some sort of hybrid between running shoes and loafers. I would have never worn them in the law firm. I wouldn't have been allowed to. So I'm going to talk about how lawyers are hacking SaaS companies, e-commerce companies. Sounds ridiculous, bear with me. So data breaches, everybody knows about data breaches, right? Target's been data breached, Yahoo was data breached, Ashley Madison was data breached. Anybody get burned by that one? Raise your hand. No? All right. So these are all the ways hackers are hacking and stealing data, right? It's a huge problem, but there's not a whole lot that lawyers can do about it besides making sure their companies are implementing better security practices and have their different click wrap terms and whatever buttoned up. But along those lines, one of the things that lawyers are doing wrong is they're messing up the way their customers are contracting at super high volume online. So, you have these agreements all over the web. You check a box, you click a button, you're accepting terms of service, a privacy policy. Companies are using this type of contracting more and more and more. They're doing millions of transactions every day. It's by far the most prolific form of contracting on the planet. But for whatever reason, consumers don't see these as real contracts. And unfortunately, our profession also treats these with very, very little deference. They're almost an afterthought. So these are real contracts. They're designed to be real contracts. Big e-commerce companies have millions of these things out there. They're designed to protect them. They're designed to do the things that contracts are there for, the reason that lawyers draft contracts. But if you're not implementing them and doing them in the right way, you're doing your clients a huge disservice. They're just not being treated like real contracts. And the byproduct there is that you have a huge army of plaintiffs' lawyers that are figuring this out. And they're figuring out ways to hack these agreements without hiring Russian hackers. They don't have to do denial of service attacks. So if you think about some of the ways, if you ignored the typo at the top of the thing there. So, if you're going to put these agreements on a website and you're going to have tiny little print there and you're going to try to sneak it in, that's the best way to have those contracts mean absolutely nothing, completely unenforceable. So let's say you have big print there and you have a checkbox and you go to court or you have a dispute with somebody and you say, well, you signed this contract, you checked it, well, prove it. Well, what do you do then? Usually that takes a long time to do, and especially if you're talking about doing this at very large scale for a big company like an Amazon, it can take months to produce enough records, CSV files, all the things that you have to do just to get to that point where you say, hey, here's your contract. Prove that it was accepted. How do you do that? Like if you're representing a tech company, how would you do that if they asked you that question right now? Could you do it in a day? Could you do it in an hour? Could you do it in a week? Did you provide the right type of notice? Did you give them the opportunity to review it? Did you give them a copy? All the things that are statutory in the e-sign law and the Uniform Electronics Transaction Act. Nobody's doing this stuff. And it happens a lot, and it is super expensive. Where this mostly manifests itself is when it comes to class action lawsuits. So somebody brings a class action lawsuit, you want to rely on an arbitration provision, you want to rely on, a class action waiver. No, you can't form your class. Best way to get out of a class action lawsuit. Well, the class action lawyers are saying, no. Prove it that there's an arbitration that's binding on this class. Very hard to do. In the case of Safeway, all these companies have been burned, and so Uber actually just overturned it, but it took them a year to get to that point. And how much do you think they paid outside counsel to get to that? Safeway lost a $42 million class action because they couldn't prove what version was in place on a given date for a set of customers. So they couldn't rely on their arbitration provision. Class action proceeds, $42 million later, they're, well, that speaks for itself. So the solution to the problem is really simple. It's just start thinking like lawyers. Like, don't start treating these things, these types of contracts, the legal events surrounding them, how they're presented, how they're tracked. Think about those like real contracts. When you draft a contract for a client and they're going to sign it in paper, or a piece of paper and ink, you don't have to explain that to them. But for this stuff, you do. It's a new type of contracting. So think about what you learned in Contracts 101, your first year in law school. That's really all you have to do. Work if you're advising tech companies, if you're in-house at a tech company, work really close with your e-commerce team and your product team and your developers and all of them, and help them understand this is important. You can't just slap these things up there and cross your fingers and hope that they're enforceable. You have to think about this stuff. Develop record-keeping procedures that are built not just to track the data, but to also be able to very easily reproduce what was there. So, we've seen it time and time again where somebody tries to rely on this type of agreement, and they'll produce to a judge a CSV file and a screenshot. And the judge is like, what the hell is this? This isn't a contract. Show me a contract. How is this a contract? So, make sure that teams are building something in the background to make that an easy process so that it doesn't take a month. So that you can produce something that makes sense, that looks, feels, acts like a contract. And then, I think most importantly, and this is the hardest one, because these types of agreements were born out of the necessity of getting contracts in place in a very frictionless environment. You buy something on Amazon, they don't want to have to stop the transaction, send you an email with a contract, wait for you to sign it, file it away, and then let you check out. It has to be very frictionless and seamless. And what the byproduct of that is companies have tried to be very sneaky about it. Tiny little print, putting it somewhere where you can't see. So to the extent that you can get that with your marketing teams and your e-commerce teams, that's what you need to do. That's it.
Thank you for joining us because there were too many lawyers volunteering at the airports tonight.
Hi. No, I have no slides, and I just came back from JFK where I was volunteering, so thank you. I hope you can forgive me in advance for being scruffy and for being out there instead of preparing adequately for this, so I'm not off book. I'm here to talk about legal technology and access to justice. I started out as an old school litigator in the late 80s and early 90s, and then I left for more than a decade, and I came back, and it was a revelation, what technology had done to the practice of law. I mean, you could literally practice law from your living room, and I do right now, so not right this minute, but the efficiencies that legal technology have brought to the practice of law are a true access to justice improvement, without a doubt. The problem is that the access to justice improvements that are in the private arena are not going to trickle down to the most vulnerable populations that we have in the United States. The trickle down will happen to relatively high information people who can pay for some amount of legal services, but it's not going to trickle down to the most vulnerable who can't pay and don't even realize most of the time that they have rights to protect. Forgive me. So, as somebody else said earlier, lawyers need technology people, and technology people really can help lawyers and can do some good for society and for the access to justice movement. There are a couple of problems, a couple of obstacles. One is kind of cultural, but instead of a problem, it really is kind of a flip side. I mean, it's actually a place, oh my, is that me? Oh, okay, so I'll jump in. Lawyers are trained to see nothing but edge cases. Where it's not just that we see edge cases, but we're actually taught to see everything as an edge case, right? So it's called issue spotting. Technologists and product developers and tech entrepreneurs tend to see things that happen in the middle, typical use cases, and they save edge cases for later. That's actually, even though it seems like a conflict, it's actually a point where we can check each other's homework and a place to come together and think more broadly about how to make technology useful in the access to justice space. Another area that seems like it could be a challenge, but is actually an opportunity, is the need for testing. The need for testing is so important in the access to justice space, because if we're going to develop tools, self-help tools, things that improve access to justice, they have to be good. They have to be effective. They can't just be easy to use. They actually have to improve the outcome of cases. Hang on. Measuring outcomes is really difficult in the tech space because lawyers don't really see the need for testing. They kind of assume that any intervention is a good intervention. Any amount of help is better than no help at all. That's true for human interventions. Any amount of representation is better than none. And it spills over into the tech space. If they have a hand in building a tool, it's better than nothing. But my answer to that is leeches and bloodletting. That used to be an intervention that people thought was really effective for a cold or the flu. So we have to test. And because lawyers are interested in proof, and tech entrepreneurs are interested in metrics, it's also a place where we can come together over this. I'm not going to promise that access to justice legal technology is a super profitable space, but if we don't have justice, equal justice for everyone, we don't have justice for anyone. So I hope to encourage people to accept the challenge.
I just want a louder round of applause for that one, please. Thank you.
Dean, where are you? I'm so sorry. Apparently I need a new prescription because I looked down and jumped over you. So
it's all good. So hey everybody, I'm Dean Sonderegger. I work for Wolters Kluwer, and my talk for the evening, she has the clicker. My talk for the evening is going to be about really a dive into the tax accounting industry of all things and how technology has changed that industry over the last 10 years. And why would you do that at a legal conference, right? Well, if you think when you look at it, what you'll find is that the changes that technology has driven in tax provide a little bit of a window into the changes that you might see in the legal industry coming down the pipe. So I'll skip my picture. So I think that a lot of the a lot of the literature, when we start to talk about the law, focuses on two different models of the law. You have the artisan, who is necessary to create a unique work every time there's an engagement, versus law being a set of repeatable tasks that a robot could be trained to do. And we have all kinds of different predictions, most of them dire for lawyers, about the impact of technology. And so that's kind of the things that we want to start to dig into a little bit here. So as we do that, I want to take a quick second to look through the value story that the professions themselves, the legal profession, provides to clients. So why do people hire a lawyer? Well, really for two reasons. One is that, as depicted by all those books there, there's specialized knowledge that they need that lay people just don't have. So they need access to that specialized knowledge. And then second of all, they need somebody to represent them in certain circumstances. And this is true in tax, this isn't true in the legal market. And what you have here is a sense of exclusivity. You have high educational requirements and you have licensure requirements in order to be able to practice, right? So what does technology do? It really does three things to that. The first thing is that good expert technology kind of breaks that knowledge barrier down. It distributes that knowledge to the lay person so they can take actions without the intervention of a professional. It democratizes it. It's, to Linda's point, it gives access to more people. The second thing that happens is that technology, when it works really well, automates a simple task so that a lay person can proceed and perform that task efficiently and effectively. In this case, that's a really neat thing if you ever hang a picture and having a laser come across, right? The other thing, the third thing that technology does is it can take complicated tasks that require a professional to do and dramatically improve the efficiency. And I'm not going to, on the basis of time here, talk through what a combine is on a farm, but it dramatically changes how effective and productive a farm is. And if you go down to India and other places like that where they're introducing them, it's a world-changing event. So when we talk about tax, right, the fundamental thing that has happened in the last 10 years in the tax market has been the evolution of consumer tax preparation software. So if you look up here, you'll see that in 2016, 55 million people e-filed their tax returns, and they did that using something like TurboTax. That means that 55 million people received expert tax advice without talking to an accountant. That's quite a change, right? Now, the first thing you might think about there is you say, well, okay, well, then that means the law firms, the tax accounting firms are losing business, right? Not so. If you look up there, the blue bars across show that the number of returns filed by professional tax preparers has been about the same for the last 13 years. However, that orange line that starts to descend there, that's the number of firms providing tax returns, and it's shrinking. And so what you see is the same amount of work and demand from the market, but efficiency tools, which occur on the professional side as well as on the consumer side, are driving it such that there are fewer preparers, fewer firms, and fewer tax accountants preparing returns. So that's the second effect. So the other thing I was going to point out is that we think of TurboTax and other software like that as just being something that fills out, it's an expert system that fills out the return, but increasingly these services have experts that you can talk to, and they have audit defense services. So that representation as part of that bargain with the professionals is being met by a software company with a very small staff of accountants compared to if everybody went in to see their own accountant. So now the tendency to say here is, okay, that's a consumer problem. That it's only occurring on the consumer side of the house. But the reality is the same technology that's being used on the consumer side is being used on the professional side, the corporate side. If you look at the top 10 accounting firms in 2003, about a third of their business came through from tax. If you look at that same number in 2016, it's down to about a quarter. Why is that? That's because, I'm sorry. That was my 30-second mark. Oh, I have to accelerate now. That is because you've seen insourcing in large scale on the corporate tax side. So now, here's my predictions that we have real quickly, very quickly apparently. So the first prediction is that we've already started to see consumer legal services come in. You're going to see a lot more people get access to law without talking to an attorney directly. On the corporate side, you're going to see two things happen. You're going to continue to see the insourcing, the same insourcing of the legal market that you see on the tax accounting side, you're going to see with corporate counsel. And we already see that. Corporate counsel outside spend is flat. Corporate counsel internal spend is growing. And then finally, and the last thing that I'll leave you with is that the efficiency tools are coming, and they're coming that allow us to do fees and service, to allow us to do legal tasks much more effectively and efficiently. What you'll see that start off with is more services provided for the same fee, but as you see more movement into into corporate counsel, you're going to see the fees start to grow. And so those are my 3 predictions. Thank you.
Okay, next we have a frequent speaker, Dan Lear.
But no less compelling, even though he's frequent.
No, and so I will give you a high sign at 30 seconds.
I'm going to go 15 to 30 seconds over. I'll tell you that right now.
Really?
It's happening.
Try.
It's happening.
Just try.
It's happening.
You can start early, that would be a way of gaming.
No, that's not any fun. Not any fun. Hack it, totally. Totally, there we go. Okay, I'm gonna have to step back here a little bit. All right, call it a rock in a hard place. Call it Scylla and Charybdis, that's your Greek. Call it the irresistible force meeting the immovable object. Call it whatever came up when I searched rock and hard place on Shutterstock. The legal ethics regime and the technology landscape of the 21st century are an accident waiting to happen. Let me give you 3 examples. We live in a world of mass media culture, right? Every company, every politician, every organization is constantly vying for our attention. Legal advertising ethics are stuck in the 70s, 1977 to be precise. That was when the Supreme Court formally established a First Amendment right for lawyers to talk to consumers. This is moving automatically. All right then. This is making it even more exciting. I'm going to finish in 5 seconds. The problem is that lawyers confuse unsavory advertising with unethical advertising. That's our second Better Call Saul reference of the night. Enter the Association of Professional Responsibility Lawyers, who said in 2015, the rules of professional conduct governing lawyer advertising are outdated and unworkable in the current legal environment. A practical solution to these problems is best achieved by having a single rule that prohibits false and misleading communications about a lawyer or the lawyer's services. That means that all of this stuff, like the New York State Bar that says a post on Twitter, quote, a tweet, is deemed attorney advertising. If it's deemed attorney advertising, the rules that require that a lawyer must include a disclaimer in said tweet. All right? Number 2. So the legal, and I'm going to keep talking about advertising, but I want to get into fee splitting. The legal advertising market basically addresses, all right, I'm pushing back here, 3 different types of advertising. Traditional advertising, we have word of mouth advertising, and then we have kind of this sleazy guy in the middle who is unethically and dishonestly convincing consumers to go to a particular lawyer. That's unethical. It should always be prohibited. The problem is that we now have so many more ways that lawyers communicate with consumers. We have legal publications, which have been online for a while, but now they're taking on some kind of advertorial bent. We have social media, which enables lawyers to communicate with consumers in a wide variety of very compelling ways. We have contract and do-it-yourself forms online, where consumers are filling out these forms themselves, sometimes being upsold a legal service, sometimes not. And we have Groupon-like technologies that enable a third party to effectively and transparently deliver a client to a lawyer. And this says nothing about, we're going to hear about robot lawyers later, this says nothing about robot lawyers or technologies that are actually doing legal-like or actual legal analysis. These technologies need to be compensated for the work that they're doing, and our current framework does not allow that. Finally, number 3. Boundaries, borders, jurisdictions. Let me just give you one example. I was a paralegal under the supervision of a Canadian lawyer representing a Washington corporation, giving advice to everyone from Racine to Romania. There are lots of good reasons that we should have local regulatory and legislative jurisdiction. But the current legal regulatory framework regarding jurisdictions is completely out of touch with the way that business and technology works today. It needs to be changed. In short, this is just 3 examples of places that legal technology, technology in general, and the legal ethics regime are not lining up. And we have a significant problem. And if we don't figure out how to fix it, we're going to have a significant mess. Thanks for your time.
I'm still in shock over here that he finished like
A minute under.
50 seconds under.
Haley from Doxley, come on up.
Thank you. So I'll just wave at 30 seconds.
All right, I'm Haley Altman. I'm the founder and CEO of Doxley. I was actually a practicing attorney for the past 10 years, practicing both on the West Coast and in the Midwest, and left equity partnership at Ice Miller to start a tech company. And you know, you think about it, a lot of people have said the death of the billable hour is coming. That, you know, at this point, we've heard it for over a decade. It's not going to go away anytime soon, but it is going to be one of the biggest sources of conflict between law firms and their clients, and one of the biggest obstacles to law firm profitability in the long run. And why is that? When we think about the consumers that we are today ourselves and our clients, they do everything simple, easy, fast. You do everything with your phone. Today alone, I boarded a plane with my phone. I ordered a car. I might order alcohol later from Drizzly. Who knows? We'll see what happens. But you know, that's what we expect. We want to do things. We want to do things quickly, and we want to do things easily. And those expectations that we have in our own personal life are starting to filter into the law firm world, and we see it when we look at profitability. And so there are a couple of indicators that actually don't play into what law firm profitability. Geography, at this point, regional law firms can compete at the same level as coastal law firms. Market segment, smaller law firms have the same ability to compete with different size law firms across the country. But one thing that's kind of surprising about that doesn't matter when it comes to law firm profitability is billing rates. So no matter the size of your billing rate, that doesn't necessarily directly impact your profitability, which seems a little bit counterintuitive. The higher my rate is, the more I collect, the more profitable I'm going to be. But in 2013 to 2015, there was a study on law firm profitability. And the most profitable firms that were at the 10% range, that they raised their rates at the same rates as other law firms that had stagnant profitability. The difference, realization rates. Realization rates in legal practices have been declining. And in fact, they're down to 82.9%. And what that means is how much are you billing and how much are you able to collect from what you've billed. And when you look at it, the traditional methods, these short-term solutions, increasing rates, the clients are starting to push work in-house. They're fighting against these increases. Cost-cutting measures, law firms have cut costs dramatically since the financial crisis, and increased billable hours plays into the same issue as increasing rates. So how are law firms going to increase that profitability? They have to focus on treating their law firm or treating their clients like partners, figuring out what is the true value that the client needs out of that relationship. What are they looking for to meet their needs? Some instances that comes around billing, alternative fee arrangements. You have to look and see. I was just talking to the director of technology at Toyota, and he was exploring different options to do risk sharing. So if a settlement was predicted to be $1 million settlement and you got it for $500,000, he was willing to negotiate some percentage of that profit or of that reduction that you're able to help him get. So law firms are looking at it in a different way. So you want to understand, communicate with your client, get to know what they want, what they expect out of their relationship, look at different budgets, and then you want to look at the evolution of the tools that are out here. Here we're all here for Legal Week with the legal technology standpoint, and there's so many great legal tech companies here. There's technologies that can impact every aspect of your practice, helping you better realize the amount of billable hours that you could be collecting by sending metrics to your clients, helping your the different touch points that the clients have. So from my perspective, I would do venture capital transactions, and once our client had negotiated the financial terms, they just wanted to know why they weren't getting the money in their account. They had employees to pay, technology to bill. They didn't want to hassle with all of the details of getting these documents, and they just wanted to be done. And they didn't want to receive couriered signature pages. So what can we do to bring the technology in to really bring efficiency to that product, so that process, so that client sees value? When the client sees value, their realization rates tend to be higher. The clients look for the combination of people, process, and technology. So while you're here at Legal Week, take a look at all the legal technology that's out there that can impact and improve the overall perspective of your clients. Embrace it, get a better understanding, and bring it into your practice. The legal industry isn't going to be the next Kodak, but it would be much better to be the next Uber.
Hi everyone, my name is Bennett Collin. I'm the founder and CEO of Cognate, and I'm here to talk to you tonight about the blockchain. So what is the blockchain? It is a decentralized digital ledger of transactions that combines powerful cryptography algorithms. So in English, what that means is there is a system for record keeping that isn't dependent on one single centralized organization. The users of that system keep the records. And combining this with cryptography algorithms allows us to have a very secure, unchangeable, and fair system for keeping a record of transactions. So what does this mean? It means that a blockchain is by nature public, secure, and immutable. And it's secure because in order for a hacker to get into the system and change a record in the blockchain, they would need to control more than half of the entire network's computing power, because all of the transactions are monitored by the users of the system, the custodians of it. And that type of computing power just does not exist right now. So from a technical standpoint, the blockchain is a back-end database that is maintained in an open distributed ledger. From a business standpoint, it's an exchange networking for peers. And from a legal standpoint, it is a transaction validation mechanism that doesn't require any third-party intermediaries. And when most people think about a blockchain, they think of Bitcoin. But there are many functions, in fact, there are 10 functions that a blockchain can perform by nature, and just one of them is cryptocurrency. So if you start to combine some of these functionalities, we can yield programmable atomic. So assets, trust, ownership, money, identity, and programmable contracts. And as many of you can start to see, that some of these functions or combinations of these functions have traditionally been performed by attorneys. So the question is, will blockchain affect the practice of law? And a lot has been written about this by many publications and very many smart people. And chief among them is Bloomberg Law, that predicts that blockchain technology will transform the practice of law. And they go on to say that firms that devote resources to being on the cutting edge of this technological transformation will thrive, while those that don't will operate at a serious disadvantage. And to me, that sounds like a resounding yes. And central to this evolution is going to be the idea of the smart contract. Ethereum is another blockchain. So there is the Bitcoin blockchain and the Ethereum blockchain. And the Ethereum blockchain is friendlier to the smart contract. And all a smart contract is a bit of code that validates a transaction. And they can be used in any number of legal applications. So it's going to lead to a whole tidal wave of different legal vehicles. So you can imagine that contract law is going to be one of the first areas to be affected. It's already being used for record keeping. Real estate transactions can be facilitated entirely on the blockchain when the deed to the real estate property and the money change hands simultaneously when both parties fulfill their end of the agreement. There's no need for an escrow. There's no need for any outside parties. Similarly, estate law, if someone has a will all of the assets are automatically distributed to the proper recipients, no need for an attorney. All of the assets are distributed via the blockchain. And finally, there's IP. About which Thomson Reuters says if blockchain is right for anything, it's IP. You could even submit your trademark through the system. And this makes a lot of sense because it's publicly accessible and it's immutable. So people can make a permanent public record of their trademark rights. Eventually, the blockchain could even be used to process applications where the application would be compared to existing records on the blockchain and accepted or denied based on those records. And even further down the road, hopefully this might lead to some sort of global protection system since there's increasing global trade and overlap, and that system is sorely needed. And does this spell the end of the legal profession? A lot of the speakers have already touched on this. Blockchain is particularly scary because contracts are automatically executed, assets distributed, enforcement is built into the nature of the technology. And as everyone has said, the short answer is no, because they'll still need lawyers in the short term to draft the contracts and provide advice, but the nature in which law is practiced might change, where it's shifting to more of an advisor role or using more technology. Lawyers might need to learn to code. And my punchline was that the short answer is no, the long answer is not yet, but everyone else has already said something similar to that, so that's all I got. Thanks.
Second to last. Great.
10 of 11.
10 of 11. I'm fully aware that we're now standing between you and either an early night or more alcohol, so I'll try and keep this quick. My name is Shmuley Goldberg. I'm not a lawyer. I've never been to law school. I'm not an ex-attorney, a current attorney, a post-pre-attorney. I'm a Tech 101 evangelist. We're going to talk about what we see happening in the tech world over the next 10 years. When we first decided and really kind of spent some time on analyzing what's going to happen, we decided to look at what had happened in other major industries. The biggest change to an industry over the last 25 years is in travel. You book flights today very differently from the way that your parents did, and perhaps even your older siblings. Travel has changed dramatically, and we tried to work out what it was. Was it the iPhone? Was it the internet? Was it digitization? And we worked out that actually it was automation. Automation was at the core of all these things at driving the industry forward. Automation is what allows for these websites and these apps to book flights, tens of thousands of flights, instantly, and helps millions of people today have access to travel that they didn't have access to before. Automation, believe it or not, has actually led to an increase in travel. People are spending more on travel. They're not buying less travel, they're consuming as much, if not more than they did, they're just buying it differently. And this is what's key to the legal profession. It comes down to two things. Automation allows for existing services to increase their efficiency, reduce their costs, and automate what they offer. And it allows for new alternative services to come into the industry. Now, over the last few years, and I'm talking 3 to 5 years, we've seen this in the legal space. We've seen the legal companies such as LPOs and alternatives to the tradition growing at roughly 30% every single year. New services like contract drafting automation are popping up, and contract review automation are changing the way that we do basic legal acts. We've also seen, and we are seeing, new startups come along at an alarming pace, offering to rediscover e-discovery and change automation and offer to really adjust as much as the legal profession as possible to fit to this new wave of automation. We've also seen in-house counsels and legal firms doing the same thing. This, some of you may recognize, is Mary O'Carroll, who's the head of legal operations at Google, who's on an absolute mission to automate everything their department does. Internal requests are no longer sent to lawyers, even if they're about laws or contracts. They've built a system which can handle and understand and answer the vast majority of legal questions that come into their department, and only escalates 10% of the questions they actually get to lawyers. They also have systems that use machine learning and data analytics to check tens of thousands of contracts to understand risk and to calculate what they need to do under certain situations. Now, people have asked tonight, and I think it's been asked and answered, what does this mean for legal professionals? Are we going to fire all the lawyers? We don't believe so. And we compare this to what happened again in the travel industry in the 1930s with this incredible new technology called the autopilot. People were panicking. Flight attendants, pilots, and everyone in the aviation industry thought this was the death of their jobs. But what actually happened was very, very different. The new pilots were the ones that embraced autopilot, those that could rely on more accurate data and better decision-making to actually do their job better, to take care of all the small things while they could focus on the large strategic decisions. Finally, what does this mean for you? How are you going to be able to embrace this the same way those pilots did? The two most important takeaways that we have for you, first of all, is hire an operations team. If you look at the travel industry 25 years ago, the leaders today were the ones that stopped hiring travel agents and hired engineers. So look out for and build now a culture in your organization that allows for legal operations, legal automation. The CIO is a role that came around less than 15 years ago and is now one of the forefronts of many organizations. Let information and automation sit at the management table. Let them have a voice in your organization. And the second thing is, as much as possible, standardize everything. Legal decisions in 15 years' time will not be made by humans. A human would make it once, explain all the use cases that it can work for, and from then on, let computers make those decisions. The more human interaction you can take out, the less risk you have from human mistakes, and more importantly, it allows you to standardize and gives you the building blocks on which you can build your own automation in your firm, in your department, or individually by defining now these are the rules that apply in each and every single case. It's easier than you think. You're not the first industry to change. You're very likely the last. But if you get on with it now, you'll be at the forefront. You'll be using the autopilot instead of letting the autopilot replace you. Thank you very much.
Okay, we have one last, but I think it's going to be very interesting, not least for sure. Oh, you figured out a podium. And then afterwards, we'd like everyone who spoke to come up. We're going to take a group picture and you can get your Evolve Law t-shirts. And I wanted to thank Nori and his Shmuley, his stand-in. They came all the way from Israel, and Nori has lost his voice. And then we have Karsten, who's come from Germany. So those are our international visitors. Brussels, sorry. Okay, geography.
Hello, I'm Jeff Bell. This is my first Evolve Law, and I was so intimidated and frightened by the threat of 5 minutes that I actually prepared a written speech that I'm going to be delivering to you in 4 minutes and 20 seconds. We have a problem in the United States. You see, the founders of this nation believed that the purpose of government was to protect life, liberty, and property from what they called the depravity of human nature, from the innate human capacity to use power to rule rather than law. They knew that government is a double-edged sword. You arm officials with the power to protect you, but those officials have the same fallen human nature as everyone else. So who is to say that they won't use that power to oppress you? From Pharaoh to Nero to the Stuart Kings, history teems with examples of such despotic governments. Even the democratic republic that the founders created had to be run by imperfect women and men. And thus, even it could turn into what Richard Henry Lee called an elective despotism. This issue extends into the interaction between citizens and corporations and between citizens in the economy. You see, if might makes right, if money decides all outcomes, meaning whoever has the money either makes the rules or wins when playing by the rules, then our society is not free. Unfortunately, today, we find that despite the best intentions, our citizens too often do not live free under the law. Moreover, those who seek to serve our polity as lawyers too often find first that they must advertise excessively to get clients, and second, that they are still only utilizing between 25 and 65% of their available capacity. And I'm citing LexisNexis and a Clio study. So what is to be done? How can we create a system where citizens live free under the law and lawyers gainfully and happily practice their profession? How do we ensure that when the government or big business or a neighbor tries to bully a citizen, that they are protected and empowered by legal advice and representation? How do we ensure that lawyers get to practice the law they went to school to learn? How can we restore the dignity to the profession that is now maligned by ambulance-chasing advertisements and yellow page platforms with purchased reviews and ratings? The solution to me is creating a marketplace that connects unhappy, unfulfilled, and underutilized lawyers and law firms with citizens who forego today their legal rights because they believe the system is unaffordable, unaccountable, and unresponsive. We must create a community of citizens who pool their financial resources in order to access lawyers and law firms who are underutilized today, and not optimally profitable. The next element is to ensure that the service is responsive, and this is where technology matters the most. Citizens need the equivalent of WebMD, and I would argue that it's not the travel industry. It's the medical industry that we need to look to as the example. You see, WebMD does not replace any doctors. Instead, it allows people to feel more informed and prepared when they go and meet with their doctor. That's what we need in the legal profession. Citizens and lawyers need secure and dependable technology to schedule and connect and communicate. That's audio, that's video, and that's text. The last requirement of our solution, together all of us, is to build a system that is accountable. In the same way that Yelp or J.D. Power added accountability to the ecosystems of many products and services, we need to create a world where clients can give feedback to the lawyers and law firms who in turn receive the training they need to improve upon their service. I truly want to paint this picture. Instead of lawyers billing half their hours and spending half their revenue on advertisements and leads, we need a world where clients arrive without advertising and they fill 100% of the available capacity of the law firm and the lawyers. Instead of citizens being bullied by landlords and insurance companies, neighbors, and even the government, they need to become informed and prepared and represented by legal counsel. As an industry, we must work together to create this affordable, responsive, and accountable legal system. And it is the fulfillment of our nation's founders' vision when we do. Thank you, and good night.
Okay, well, anyone who spoke, if you could come up and we can take a picture, and for the rest of you, there's still more alcohol and food, and go check out all the vendors, and thank you again to our sponsors, Wolters Kluwer and Legal Shield.
And have a great week at Legal Week. Legal Tech, woo!